We are back on Morning Line. Our guest with us this morning, Davidson County District Attorney Glenn Funk, talking a wide range of issues, taking phone calls, comments on Facebook. I'm curious, from where you sit right now, and as we're coming out of some of these shootings, and the most recent one in Texas, you prosecute based on the laws that are on the books for you. Are there laws that you would like to see change in any way, perhaps toughening, what you can do, how you prosecute? Is there anything that jumps to mind where if, the legislature came to you and said, which they won't, but if they did and said, General Funk, give us a list of your top 3 priorities that we could change for you with regard to criminal prosecution and laws. Is there anything that really jumps to mind for you?
Well, the legislature has done some things following what we've done. It used to be that it was a felony if you had a simple possession even of marijuana for your 3rd offense. And it's like, well, why would you then, so we stopped prosecuting as a felon, felonizing simple possession. And sure enough, 2 years later, the legislature took that off the books, right? We stopped prosecuting drug-free school zone cases, and there have been 2 amendments to the drug-free school zone law that have greatly reduced the applicability of that sanction. And so they do sometimes follow the things that we are serving as a laboratory for the state, because we're keeping careful track of our statistics, and they're taking notice, while sometimes they like to kind of prod Nashville, and sometimes they like to prod me. But they're following what we're doing and seeing and adopting some of our safety measures.
Listen, before you, I apologize for this. I wanted to ask you before I let you say what laws you might want to change. You're short on time with regard to what the legislature has done. I'm just curious your take on the truth in sentencing law. And the only thing I'm referring to there is, and I've heard from more than one individual who works within the incarceration community, including the sheriff and others. Truth in sentencing. You get a conviction, someone gets 12 years depending on the crime, and typically on good behavior and such, maybe 30% or something like this. Well, now the legislature has passed this, and they've done it before. I talked to David Rabin. They did it before and realized what a mistake it was, and they rescinded it. Now it's back again because it was an easy thing to push during an election year. What's going to happen with this? If someone gets 10 or 12 years and now has to serve all those 12 years without any good behavior, good or bad?
Well, the problem is it's a misnomer to say truth in sentencing. There's nothing that was untrue about our sentencing. Our sentencing said 12 years, and they could be considered for parole after 30% of that time, and a parole board would make that decision. The TDOC was allowed to give some behavior credits, from 4 to 16 days a month of behavior credits, which we want to encourage good behavior in the prisons, right? We want them, people that are serving their time, to engage in programs and get education and job training, and that if there's no incentive for that, then they just watch the clock and the calendar and then get released, and they got no chance to have any rehabilitation. Right. And plus, if you're a Department of Corrections employee, you want people to be incentivized to have good behavior instead of bad behavior, because you want to make sure that that helps you control that population in a safe manner for them and for you. And so you call it truth in sentencing. Really, what it is more definitive sentencing, right? So you can and as a prosecutor, I like to be able to tell a victim, listen, this is what the sentence is, and this person will not get out until this date. Which is nice to be able to say in a definitive way, but on the other hand, how can I predict whether this person is a continued danger 3 years from now, 4 years from now? And how do we, Centoya Brown, graduated from Lipscomb while she was incarcerated, and she did every program, and she was a model person while she was incarcerated, and so the governor reach down and use clemency. But if we eliminate the parole board, then the only safety valve is the governor, and that just won't happen very often. So
you're going to have overcrowding?
So, we're going to see a significant increase in the number of inmates in our Department of Corrections. There will be no way to necessarily assess years down the line, is this person a continued threat? And the other thing it does is it gives incredible amounts of power to the prosecutor, because everything's built to have checks and balances on the prosecutor's power. The grand jury, the judge, the jury that decides guilt or innocence, the judge that determines the appropriate length of sentence. But another check is, we plead somebody, then the parole board might say, well, after all this time, we're going to agree to parole this person and supervise them in the community instead of continuing to keep them in prison.
Right.
If you have a situation where there are fewer cases that can get parole, that means the power is in the prosecutor. And a prosecutor who is trying to look at a crystal ball and say, okay, well, this is what happened in the past, and this is what the appropriate sanction is, and this is where we want to be in the future. Well, if I give somebody 20 years, and so no one can even put a check on what my decision was in 2022 all the way up to 2042, then is that what we want to do, is make us, kind of soothsayers as far as what the needs are. And the costs are, if we were to all the way eliminate the parole board, if we were going to make truth in sentencing, essentially a concrete definitive sentencing for all crimes, we would probably triple the size of our number of folks incarcerated. We went from 7,000 inmates in our Tennessee Department of Corrections in around 1970 to 30,000 in 2015. We could see that triple we could see that triple again.
Well, there'd be no place to put them. So which means state lawmakers can go this way. They're going to spend billions building new jails or prisons.
The fiscal note on the bill that passed this year was only $29 million. My prediction is that will be very much underrepresentative of the true costs to the state.
Come on, that wouldn't build one prison. I'm guessing they're banking on private industry, privatizing.
But it's not just the costs to house folks and build the prisons and maintain the prisons. There's cost to Tennessee families too. Right, because every person that's in prison has a family, and many of them have kids, and some of them have spouses, and parents, and so it's really a situation where we've got to balance community safety, right?
That's number one.
Number one, with having a healthy community, with also supporting victims, because we've always got to be looking at what's and it's not good for a victim to have to go back every 2 years or every 4 years to a parole hearing, because that's just ripping the scab off and making them get re-victimized. On the other hand, there should be some sort of check and balance on what the decision was of the prosecutor and of the criminal justice system at the time of sentencing. In most cases, first degree murder, maybe not, at least not for an extended period of time. Some of these crimes like child rape and things like that, okay, understand that, because incapacitation is part. It's not just about rehabilitation and deterrence, it's about incapacitation for the folks that are the most dangerous. But you've got to look at all those different reasons behind the criminal law as you are deciding, what a proper sentencing scheme is. The group that put together our sentencing statutes in 1989, judges from across the state, legal scholars from across the state, and they did a really good job. It's still basically intact, though there have been some continuous modifications. Some would say not always improvements, but the legislature at the time thought it was an improvement. But just coming in and just making it the easy solution, with a great title, truth in sentencing, I think, I think we need to be able to analyze cases on a case-by-case basis, and we also need to make sure that folks in the corrections system have an ability to try to work toward rehabilitation and try to keep their focus also on community safety.
It makes just such complete sense. And where we're going now, it's going to this law that they just passed will be reversed, not immediately. They're going to have to rescind it because of the overcrowding that will occur. I'm guessing within 5 years. Maybe sooner. It will. Trust me. We'll talk 5 years from now. Save this. It will be rescinded. It was a mistake, and it's not going to stand 5 years from now. They can't go at this. It's just not going to work.
I think that careful monitoring. And in Davidson County, we're going to be careful about how we monitor the cases as they come through to make sure that the dispositions under the current sentencing scheme are appropriate. But that, we're going to have to be very, very intentional about the way we approach cases.
General, thank you for coming on and tolerating my questions. As always, it's good to see you. Well, I thought maybe, he'd just come on last year before he's still coming on. You'll come on again, won't you?
Yes, I will. I'll make that commitment.
Okay, even though you won't talk about pending cases.
No, I will not.
And I'll keep trying. General Funk, thank you for coming on.
Sure.
Appreciate your
Good
time,
being
sir.
here.
We'll take a break. I'll be back with a programming note right after this.
I will. I'll make that commitment.
Okay, and even though you... Let's go to Diana. Hi, Diane.
Hi, glad you're having this program. I've evidently had a lot of misconceptions about this myself.
Renting out a property for the long term is a business activity.
You come hang out in